Good evening, ladies and gentlemen. I'd like to welcome you back to another edition of Foreclosurepedia Podcast, Foreclosurepedia Podcast presentation of Foreclosurepedia Radio Network, which premieres each Sunday evening at 2300 hours. Tonight's presentation is a special presentation, and that's because of the fact that we're extremely concerned about the state of the industry and their ongoing and concerted attack upon the free speech of United States citizens. It's precisely how I take it. There's no two ways around it. And so as you can see right here, we're getting ready to move to a new server. And we're going to move over to Bonhoeffer. And the reason we're moving there, because we feel that there has been the creation of a chilling effect upon free speech, which is one of the most insidious and damaging forms of assault upon the Constitution of the United States, in my opinion. And this has reared its ugly head once again. This has reared its ugly head because of the fact that we went ahead and we stated that Assurant property needed to pay us money. Monies that it was owed for months. This isn't just regular, gee, we missed the payment. For 3 consecutive months, we engaged in civil dialogue with these people, and we never got a check. The check was in the mail. The check was in the mail. We never got it. We submitted multiple W-9s to Assurant. They still couldn't get us the check. So what happened? It culminated on the 4th of October, and Mr. Jason Rosenberg of Alston Bird sent us a letter. And the letter is RE, referencing cease and desist. Hey, first thing there, Jason, you're not a judge. You can't tell me to do anything. Now, you can file a motion. You can file whatever you want in court, young man, but you can't give me orders. Who do you think you are? Do you think because you're a member of the Anti-Defamation League that you can come to me and tell me what to do? No, it doesn't work that way. You're a lawyer. You understand the canons of ethics. So Mr. Rosenberg filed at the 11th hour on a Friday a crazy and insane diatribe, in my opinion, and has ever since then refused to take any phone calls. His secretaries have refused to put him on the phone. I don't know how law is practiced elsewhere, and I don't know what they taught at Northwestern. But I do know when you're a lawyer and you send language such as, once we have confirmed receipt of this check, Assurant will consider this matter closed. We suggest you do the same. You don't threaten me. You don't tell me what I need to do or what I don't need to do. If I want to consider the matter closed, so be it. If I do not want to, that's the beauty of the United States, sir. And you're actually over here, in the Martindale directory. I went through your curriculum vitae. It appears to me at least, that you should have graduated from law school. You have a Juris Doctor, I believe. I'm looking at some of these cases that, you participated in, and I would have thought you realized that you were not a judge. Just because Assurant pays your bills, just because they are a multi-billion-dollar publicly traded conglomerate, you can't order me what to do. Now, you can go to the court and tell them that you want them to silence me. You can do anything of that nature. But you can't tell me what to do there, Mr. Rosenberg. And I will tell you straight up, I consider that personally to be very intimidating. Now, in the letter that he wrote me, and I'm going to get this up for publication because Mr. Rosenberg still doesn't want to communicate, and I want to bring all of this into perspective. Mr. Rosenberg stated, I can no longer communicate with any Assurant employees. Well, here's the problem, ladies and gentlemen. You see all these work orders over here? These are all work orders that I'm owed monies from FAS. They are owned by Assurant. So in my humble opinion, what Mr. Rosenberg is trying to do is get Assurant out of the way of having to pay us for anything. It's not going to happen on my watch, counselor. It didn't happen with AMS REO, counselor. It didn't happen with CWIS LLC, counselor. You're not going to take our money. With specificity to my claims and how I thought and how I felt about Miss Phelps, Mr. Irwin, and Mr. Graham, there is nothing that is going to change my mind in the fact that I felt that they had come together to orchestrate the defraudment of Foreclosurepedia, the company. You don't have the power to tell me how I have to think. This is not Nazi Germany, Mr. Rosenberg. You are not Mr. Eichmann. You are not going to tell me how I need to think, how I need to feel, what I must buy. You don't have that power. All I ever asked was to be paid the amount of monies we were owed. And now you've made it so that we cannot even work with FAS anymore. I cannot even inquire about the monies owed. What you have is a tremendous amount of federal properties now that are unwinterized. We are in the middle of a storm up here. Tropical storms making beachhead up through here into the Tennessee Valley. It's going to be below freezing in the mountains, and so you have the possibility of compromised piping. Those pipes bust, Mr. Rosenberg, you're on the hook, not us, because you ordered us. You demanded us to not communicate with Assurant employees anymore. If we get late charges or back bills, that lays upon you, Mr. Rosenberg, counselor, because this is, everybody hear that? This is your letter, counselor, and you've refused to grant me a phone call. You send this letter in the dark of night, and in all honesty and candor, it's about 4:50, about 16:50 Eastern Standard Time on a Friday. Snuck out of the office, refused to take any calls. What'd you think, counselor? We were going to give up the thousands of dollars that FAS owed us? You think we were just going to go away? It doesn't work that way, counselor. I wanted to bring this to a conclusion, sir. I wanted to reach out, have a civil phone call. It couldn't happen. And what I'm concerned about now is that the thousands of other contractors are going to be treated the very same way as direct result of this merger. But let's just talk. I want to go ahead and I want to talk a little bit, because you also made some statements in here that, I'm not allowed to dox any information about social media or education. Well, you can see right here, are you going to sue Google, counselor? Because this is public information. This isn't private. You put this on here, or you consented to it. I mean, are you gonna sue LinkedIn and Google here because you have a profile? So let's actually get down to the brass tacks here. The speed and ease, and this is incidentally the 19th of April 2012 at 14:13 p.m. from the Kansas Law Review. The speed and ease by which information about jurors is now discovered online has led attorneys to increasingly investigate and research jurors. One prominent trial consultant even claimed that, quote, anyone who does not make use of internet searches is bordering on malpractice, end quote. Now, counselor, are you telling me that lawyers are allowed to obtain and to present information that is publicly accessible by and through Google, but that people are not? Are you telling me that because you have a Juris Doctor, that you are granted and accorded rights and privileges with specificity to the ability to learn that I, as a citizen of the United States of America, am not entitled to? I mean, it boggles my mind. Now, you made a statement in here about defamation of character, and I wanted to talk about that just a little bit. Because I wanted to talk about a case called Global Telemedia International Incorporated versus Doe. Let's make sure we're all on the shepherdizing list here. Let's make sure we all understand the totality of law, because it's going to come down the pike, counselor, because We're not backing off the money that FAS owes us, and you've prevented our legal right to participate in a legal contract that involves interstate commerce, counselor, under the Uniform Commercial Code. According to you, we cannot talk to anybody in Assurant. You're the only person we can talk to. I'm talking to you tonight, counselor, because you wouldn't take my phone call. I invited you to speak with me this evening. You wouldn't do it. So let's talk just a little bit about what's going on here. The context and totality of circumstances. It's not even bullshit around. We all understand this. We all understand precisely what is going on. Let's talk about specificity, counselor. Opinion. If I base my opinion on a set of facts, it does not rise to the level of falsity. 1,000 cases that deal with this. The facts were, and the facts that are in play, that 3 months ago we performed our first 3 services for Assurant Property, your client. We asked over months to be paid for them. And for months, we never received a check. Mr. Juan Irwin asked us to resubmit W-9s to have another check cut. We did that twice, counselor, and still did not get a check. No jury in this nation is going to state that based upon those set of facts, and those are facts that would have to be agreed upon by both of us, because they're in the record, they're in the emails, no avoiding them. My opinion that I derived from that is my opinion, counselor. Statement is pure opinion, cannot be the basis for a defamation claim. The latter is an opinion. So what constitutes a moron is subjective view that varies with the one person. One's person moron is not necessarily the next person's moron. You know, I don't want a big pissing match, but you know what I did just to, I'm sure you've heard of the United States Congress, you know. How much of a shitty deal did you sell to your clients? Let's take a listen here.
July 1, 2007, tells the sales force the top priority is Timberwolf. Your top priority to sell is that shitty deal.
So, counselor, is that defamation? Is that defamation, counselor? Because he is articulating the fact, Mr. Levin, the Honorable Mr. Levin, is articulating the fact, the man in the dock there, it was his shitty deal. Now, we know when you actually review this whole thing, and you're going to review it. Let me scroll up here. I mean, you can come on through here. That way you can see the context. Here you go. Every single time that Goldman Sachs guy opens his mouth, I swear I can actually see shit. I guess we will give them a pass then, motherfucker. Karma bitch. Fucking assholes. I don't know. You know, counselor, I don't know. I don't think anything I've said rose to the level of defamation. Matter of fact, I know it didn't, because you can't call my opinion defamation. Here's what it is. Here's what's going on. There's been a disturbing increase in lawsuits brought primarily to chill the valid exercise of constitutional rights of freedom of speech and petition for the redress of grievances. The legislature finds and declares it is in the public interest to encourage continued participation in matters of public significance, and that this participation should not be chilled through the abuse of the judicial process. To this end, section shall be construed broadly. This deals with slap litigations. That's what you're threatening against me. Strategic litigation against public participation, albeit the jurisdiction is not California. And with that point, counselor, because you bring up and you beat the drum about Georgia, let's get over here. Let's talk a little bit. It's the Foreclosurepedia disclaimer page. You understand and agree that Foreclosurepedia and any of its subsidiaries or affiliates shall in no event be liable for any direct, indirect, incidental, consequential, or exemplary damages. Let's talk a little bit about jurisdiction, counselor, because it's spelled out right here. I'm not going to bore everybody with reading it. When you or anybody goes to my website, if you choose to read the disclaimer, you can. If you don't want to, that's your own business. But it's not my problem, counselor. It's not my problem. It's not going to be my problem. This is where we're moving. Same place that hosted WikiLeaks. We're done. We're done. We attempted to simply work and be paid. That's obviously not going to happen. It's where it's going to be hosted at. The final part, I wanted to talk a little bit about your clients and how I do have the basis of fact to articulate my opinion, counselor. American Security Insurance Company. You heard of them? Because I'm damn sure your clients have. And that's Assurant. Why? Because they own them. Let's see what they're talking about. Kickbacks are commonly paid by ASIC to U.S. bank and other mortgage lenders. I want to make sure you get a good view of this case. I'm not bullshitting it. I'm not making it up. This is the direction I am going. It's not going to stop. And I want to talk just a little bit additionally about the Hofstadter case. That way, counselor, we're both on the same page. And let's talk just a little bit about Assurant. ASIC and its parent company Assurant. That way you see, counselor, it's not just me, reaps billions of dollars in premiums. For example, in 2010 alone, Assurant collected approximately $2.7 billion in premiums through its specialty insurance division. The kickback arrangements between ASIC and its lender clients are unquestionably unjust. Multiple courts have said it's unjust. So where, counselor, do you think I came to the ability to articulate my opinion based in such a manner that I thought I might be defrauded? Not just from the employees, counselor, but from your fellow counselors. From your fellow counselors. I don't know, maybe sue the courts. Maybe they're all in defamation as well. I don't know. But here's what I do know, counselor. Here's what I do know. I think that this entire pissing match has been a waste of everybody's time. I think Assurant should have paid us when they were supposed to have paid us. Bar that, should just sent the check. But for you to step into the mix and on the 4th of October, 2013, at the 11th hour, fire a shot across my bow and then screw me, personally, in my opinion, out of all our money with FAS, that's some low-down bullshit, counselor. You should have taken a phone call. This is a testament to the fact that you, as a lawyer, have refused to communicate with me in any meaningful fashion. I hold no contempt, no malice against any of you people, counselor. I like the people at FAS very much, and now, unfortunately, I'm going to have to reveal my sources, who were there, and who got us working there. And those lives, counselor, unfortunately, are going to be tarnished. Why? Because they went out of their way to help us work, sir. And now their careers are going to have been ended. It's a tragedy, sir. You could have taken a phone call and ended it. This isn't about doxing. This isn't about defamation, counselor. This is about the fact that we went out into the field and we busted our ass, and all we want to do was be paid, sir. But because you drafted this letter and you said I cannot communicate with anybody at Assurant, can't get our money now. I have no other choice. I have to reveal my sources, and I have to reveal the reams upon reams of documentation that is going to send ripples through this industry, sir. It's a tragedy. Ladies and gentlemen, I thank you for tuning in to another edition of the Foreclosurepedia podcast. This is the point that we are with the industry, that if the industry does not like you, that if they do not like what you have to say, they'll threaten to sue you. You got to ask yourself as contractors, at what point in time are you going to draw a line in the sand? These law firms are going to keep coming and coming with these slap lawsuits. In all fairness, Alston Bird has not filed yet. However, I would anticipate they will, and I'll state this very clearly on the record, that we will vigorously file discovery requests, and we will lay barren this industry. I have an unholy war chest of funds that I will bring to bear upon this situation. Thank you and have a good evening.